This jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave that stated on at least 9 or 10 different times exactly what a unanimous verdict was and how to come to that unanimous verdict and how to record that unanimous verdict. And there is no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was charged, neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth was saying, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There is nothing special about this case. There is no special application or procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the courts refer to them as an extraordinary jury, and I know the court had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications that the jury submitted to them, which the Commonwealth would submit, were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they had reached an impasse as far as their deliberations were concerned, as it pertained to the charges. In the final note that was submitted to the court, they referred to the charges in the plurality, twice within that note, as it pertains to exactly what they were stopped. When it comes to what they were communicating and reporting to be at an impasse in regards, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate and in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether they're personal, professional, who they talked to, what they talked about, how those things have formulated in their minds. The intense pressure that they felt just looking at the affidavit from the one juror in regard to the impoundment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that, that is exactly what the case law advises against and governs against, as far as taking this sort of post hoc, weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time.